Hello and welcome to Big Deal. I'm Nisha Poddar. Now, amendments to the competition law have been passed by the Parliament, and the Competition Commission of India is in the process of making detailed guidelines based on these amendments. Now, these changed rules will change the way India does deals, mergers and acquisitions, and firms compete with each other in the marketplace. So the key highlights include low deal value threshold for CCI submission at 2,000 crore rupees, expediting the approval process, DG's enhanced powers on search and seizure, open market purchases before CCI approval, control definition changed to material control, hub and spoke cartel being introduced, penalty becomes harsher, and settlement and compensation introduced. Now, to put all this into perspective and especially to throw light on what's new in the final amendments compared to what was proposed, we have with us two senior legal experts joining me on the show, Pallavi Shroff and Amit Sibal. Thank you so much, both of you, for joining us, and welcome to CNBC TV 18. Now, Pallavi, let's start with you. While a lot has been discussed on the amendments when they were proposed, there are new areas of concern and technicalities that have really emerged after seeing the final bill which has been passed by the Parliament on the deal threshold especially. So what do you think is the intent here? Is it digital deals to be covered more effectively? I ask you because some of the corporates feel that it will bring a large number of deals under the CCI scanner, and also having the Parliament to really legislate on this threshold takes away any flexibility on the amount.
So, yes, Nisha, I think that the deal value threshold criteria is a new criteria which has come in, under which we don't know how they will define deal value. It is defined to mean any form of consideration, whether direct or indirect, whether deferred or not. But I think we need more clarity on that definition, certainly. The other aspect is that the target must have substantial business in India. Now, if you're looking at foreign to foreign deals, I think that could be one way of saying how many deals will come in. But what happens to Indian companies acquiring Indian companies when they already have substantial business in India? Well, we don't know what that substantial business definition will be. And will this in any way try to take away the smaller deals, which really don't need to come to the CCI? I think that's a question that's still open. The second issue is, when we were debating this earlier in the Competition Law Review Committee, the idea was that there were several deals, particularly in the digital markets, and the tech sector, which were not being scrutinized by the CCI because they didn't meet the thresholds, or they covered under the de minimis exemption. So I think this is really to cover all such deals, and I agree the deal value is ridiculously low.
Yes.
And,
all right.
So it's not going to stand the test of time. I think before we start implementing this, they will need to change the deal value threshold. I mean, the number.
Well, you think that there will be a revisit on this?
No, it is so. I hope so. Now the law is passed, so it can't be unless they want to use the provision in the Act where they say every 2 years you can relook at the thresholds and change the number,
So my understanding from the former CCI chairman when this amendment was proposed was that let them all at least notify, and not all will be really assessed by CCI, but at least we will not miss out on several deals which are going unnoticed just because they are managing to be way below in terms of deal value. So that was the understanding given, but I must also say that the turnover impact or threshold that was given earlier has managed to pass one very large, deal and a merger in the exhibition space, which ideally should have come under the CCI purview if that, they had not matched that one particular criteria of turnover being below the threshold value. Amit Sibal, jump in on this. Very interesting part to really deal with. What do you think about the deal threshold? What are your clients now saying?
One way that it could have been approached, Nisha, could have been to have a higher deal threshold value At the moment, it's roughly the equivalent, 2,000 crores is roughly 250 to $300 million. Now, they could have had it a little higher so that it would be sustainable over time, and then used the exemption provision under Section 54 if they felt that they wanted to exempt smaller deal sizes. But that's not the approach that's been taken. I think there's not much that they can do at this point, since it is now cast in the provision. But what they can look at is having regulations on the two aspects that Pallavi touched upon. That is, what is meant by deal value, because we need clarity on that. When you have a merger transaction, an acquisition, or an amalgamation, it can come in various shapes and forms. It can be, for example, a share swap. So how will you decide what is the deal value? It may not be a simple case of a $300 million consideration. Consideration comes in various forms. People structure deals in light of this very provision, and therefore you'll need guidance and clarity on that.
Right.
And secondly, of course, guidance is needed on what is going to count as substantial business operations in India. Now, obviously, given that asset value and turnover are not under consideration in this particular new threshold that comes with the amendment, you cannot have guidance saying asset value or a particular turnover value to constitute substantial business operations in India. Otherwise, it defeats the purpose of this provision. So you'll have to carefully look at what that is. It's not easy to say what it should be. But for example, in the case of a company in the digital markets, you have to start looking at number of users, looking at regulations that are specific to particular sectors.
Yeah. No, that's right, Amit. And in fact, conjoining this with another very important aspect in terms of the definition that is really required from the CCI and its fine print is also the penalty. It will be now based on global turnover derived from all the products and services versus relevant turnover that you mentioned. So now penalty again will require to be not just defined, but in my view, it's become also much harsher than what was there in the proposed amendment. So any reflection on this, why this has been brought in? And does it have anything to do with the digital and big tech, which is looking at India for several acquisitions and a big play? So India is trying to be a lot more protectionist in its M&A game in this space.
So we were just talking now about merger control. We are now moving to enforcement. So if just to put it in perspective, if you have a violation of abuse of dominance or a violation under Section 3 that is a cartel, then how is the penalty to be calculated? Now, it was earlier, as per a Supreme Court judgment, that the penalty would be based on a particular percentage, as the CCI may decide, of the relevant turnover. In other words, it must be related to the violation in question. So if it's a cartel relating to a particular product like aluminium phosphide tablets, then even if that entity produces other kinds of tablets, the turnover that will be levied, will be the basis for the penalty, will be aluminium phosphide tablets turnover for that particular year. Essentially, what this amendment does is to reverse the Supreme Court judgment. In other words, it now says that, look, it will not be relevant turnover. It will be turnover of all products and services, and that too, it will be globally. Now, you asked about the process. This comes in just at the end. It is not put to stakeholders for comment. It is not subject matter of the standing committee's report, and it comes in, I believe, from the ministry right at the end. So not an ideal process which has led to this outcome. Motivation, part of it appears to be, Nisha, certainly related to capturing turnover of digital market companies, where in fact you might have turnover that is outside of India, and it's hard to define the turnover that is in India. In fact, with certain big companies in recent cases, CCI has alleged that they have not given the right numbers for India. So to avoid, I think, that controversy is certainly part of the motivation behind this amendment. But having said that, the amendment is not restricted to digital markets at all, and it will apply to companies across the board. So if you have
Right.
MNCs, for example, their global turnover is already in the picture.
Yes.
They may, when they do business in India, choose to structure their business in a way that they avoid that risk by restricting the business of that particular company to a narrow sector so as to protect
Yes.
the rest of their global turnover as a whole.
Right.
But of course, you have Indian companies that are also MNCs, and their global turnover may also be subject to
Very
this
important
particular
point there.
amendment.
A very important point there made, Amit, that now the structuring of the global companies when it comes to Indian operations could be really changed to really comply with this rule and to, de-risk themselves from this particular rule coming in. Pallavi, any words on this? Anything to add?
I think this is,
Yeah.
some countries do look at global turnover, but I think in this, my own view is that this has gone a little too far. I can understand if you're looking at the global turnover of that product which you are investigating, but to look at global turnover of all products or services that a company is manufacturing or selling, is how is that even relevant? Because what are you trying to do? You are trying in a way, what was the theory of harm that you were looking at? That there was a market that was skewed by virtue of, that cartel or whatever other damage that was done. And you were trying to rectify that and penalize for not behaving correctly. Now,
Right.
how is that global turnover relevant for what company A did in India?
Yes. Right.
So
So this
I
is
can
something.
understand if they took India turnover, if at all. But global turnover, I think there is no harm caused globally.
Yes, yes. No, Pallavi, so that particular point was not up for discussion and it has made its way in the bill.
Yes.
So CCI in its fine print will have to really define and really articulate it properly for the comfort of the companies which come under this.
But this is
purview.
this is a way of getting over the decision of the Supreme Court in Excel Corp,
Yes.
which
Yes.
insisted that it is on the.
So that proportionality debate has been
Yes.
really taken off
Correct.
over here. All right, so three
Correct.
important clarities that are required: deal value clarity, how to define deal value for threshold to be defined, then also the business operations, substantial business operations in India, how is that
Correct.
defined? And the third one is also the global turnover, how is that going to be defined and whether it's legit in terms of really assessing them for their India operations. So these are three important clarifications sought, but we'll discuss more about what else comes in the amendment, which is going to impact the corporate world, which is into deal making, right after this short break on Big Deal. Stay tuned.